Hi, everyone. This is Jennifer Mondino with the Time's Up Legal Defense Fund at the National Women's Law Center. We are to be doing a training today on state civil rights remedies for gender violence at work. I'm going to give folks just a couple of minutes to log on, and then we will start in just a moment. Hello again, everyone. This is Jennifer Mondino with the Time's Up Legal Defense Fund at the National Women's Law Center. We are today doing a webinar on state civil rights remedies for gender violence at work. I wanted to start out by thanking all of the attorneys who have volunteered for our legal network for gender equity. We are so appreciative of your time and could not be doing the work that we're excited to do at the Time's Up Legal Defense Fund without all of your fantastic work. So thank you for that, and thank you for joining us today for the training. I also want to thank our terrific panel of presenters. We have Blanca Bañuelos, Julie Goldscheid, Ilan Mazel, and Zoe Salzman. And I also want to thank my colleagues at the National Women's Law Center, especially my team members, Nicole Felt and Marisa Zacarias, who are here with me and are part of the Time's Up Legal Defense Fund team and helping to make these webinars happen. So I'm going to very briefly introduce our presenters. You all should go and read more about them because we're just thrilled to have them sharing their expertise with everyone today. I don't want to take away their airtime, so I'm going to go through this quickly. First, we have Blanca Bañuelos. She is the director of the Migrant Unit for California Rural Legal Assistance, where she supervises substantive advocacy and litigation in their 6 migrant offices. She has worked with and on behalf of agricultural workers throughout California's Central Valley for over 14 years and has represented farm workers in sexual harassment cases in both court and administrative settings. Professor Julie Goldscheid is a professor of law at the City University of New York, which we know as CUNY, School of Law, and there she teaches subjects including civil procedure, lawyering, and courses on gender and law, and where she helped develop the Family Law Practice Clinic. Her scholarship focuses on gender equality with a particular focus on gender-based violence and economic equality. Ilan Mazel is a partner at Emery, Sally Brinkerhoff, and Abadi, which is a public interest law firm based in New York City. He brings a wealth of expertise as a civil rights lawyer and is nationally recognized and often writes about helping the most vulnerable populations, including people with disabilities, victims of police and prison abuse, wrongful convictions, and victims of sexual harassment and all forms of discrimination. And last, but certainly not least, Zoe Salzman is also a partner at Emery, Sally Brinkerhoff, and Abadi. Her diverse practice includes representing people, companies, and nonprofit organizations in challenges in many fields, including employment discrimination, sexual harassment, and police and prison abuse. And she and Ilan together have worked on cases applying the laws we're going to discuss today, and as has Blanca, and they're going to be sharing some of that practical experience with us in the presentation today. So very quickly, the format we're going to have for the webinar today, first we're going to hear from Professor Goldscheid, who is going to talk about the circumstances in which civil rights claims may be useful, the types of available remedies, and give us an overview of the relevant case law across the country. Then we're going to have a moderated panel of sorts with Blanca, Ilan, and Zoe talking to us about their experiences and advice about applying these claims in practice based on their experiences in New York and in California. And then we're going to have time for questions from our audience. So we invite you all to submit questions to us through the chat function that you see on the screen. We're not going to take questions throughout the presentation, but we will see those questions and we can raise them after the substantive presentations. A few housekeeping notes for today. Please keep for the folks in the audience, please keep your sound on mute, especially if you're on the phone. If you have any questions about logistics or you have substantive questions for our presenters, send them to us through that chat function. And without further ado, I am going to turn it over to Professor Goldscheid.
Great. Thank you. Can everyone hear me?
Yes, I can hear you.
Great, thank you. Okay, so thank you, Jennifer, and thanks to Nicole and Maria Fernanda, and to Blanca, Ilan, and Zoe. I'm really delighted to be a part of this webinar series and to be a part of the work that the National Women's Law Center and the Time's Up Legal Defense Fund are doing to support survivors of gender violence at work. So I think the first slide now. Great. Okay, so as Jennifer said, my presentation will give an overview of state civil rights remedies that can be used for gender violence claims. And I'll just say at the outset, by gender violence, I mean sexual assault and harassment, also can include intimate partner violence, and these laws may apply to cases of stalking and in some cases trafficking as well. And I think that'll become more clear as we go through the statutes. So what I'll do is I'll talk about what these laws are, when they may be useful. I'll give an overview of the different statutory frameworks that are used in the different states. I'll talk a little bit about the statutory requirements and how they've been interpreted, and I'll highlight some notable case law. Next slide, please. Great. So state civil rights remedies, what are they? So as the name suggests, they're state statutes that provide a private right of action against the person who committed an act of gender-based violence. So what's important about this and what distinguishes these laws from many other civil rights statutes is that these generally provide a cause of action against the individual who committed the act of gender violence and not against an employer or against some other institutional defendant. These laws are on the books in about 14 states, plus the District of Columbia and a few municipalities. So the statutes in different states are drafted in slightly different ways, although they have generally similar proof requirements, and I'll talk about the different approaches and the proof requirements through the presentation. But at the outset, since it's always helpful to work backwards, remedies typically include compensatory and punitive damages, injunctive and declaratory relief, attorney's fees and costs, and generally there's no damages cap on relief, so that could be really useful to plaintiffs, to people wanting to bring suit. The laws also may have longer statutes of limitation than Title VII or tort laws, and generally there's no exhaustion requirement. So those features may make these laws more useful than some of the other laws that people typically use when their clients want to bring a civil claim in cases of gender violence. So next slide, please. Great. So let's talk a little bit more about when they can be useful. So these laws can be useful when there are instances of gender violence that are committed outside of work or housing, and particularly outside of traditional work or housing circumstances. And I identify work and housing because workplace discrimination statutes and housing discrimination statutes as well provide a cause of action when someone's sexually harassed, sexually assaulted in their home. But these state civil rights remedies apply regardless of an employment or other relationship. So they may apply in cases of sexual assault by a medical professional. So there are some cases involving these laws throughout the country where someone was sexually assaulted by a medical professional who was associated with someone's work. For example, someone who was administering a work-related medical exam. They also would apply to non-work-related medical exams that result in some sort of sexual assault as well. They also will apply to a colleague if a colleague commits an act of sexual violence outside of work, to gender violence committed by a work associate who isn't an employer or a coworker, or of course to an intimate partner, an acquaintance, or a stranger. They also can be useful in cases of gender violence at work, so sexual assault, sexual harassment that takes place in the workplace. And these laws may fill gaps in current laws, so I'll talk about what some of those gaps may be. So I'm sure you all know that federal law and every state law prohibits sexual discrimination at work, and that sexual harassment and assault typically are recognized as a form of sex discrimination. But you all also probably know that state laws vary as to how workplaces are defined, for example, in terms of the number of employees that define a covered workplace. And also, state laws vary in terms of who counts as an employee for purposes of accessing anti-discrimination laws. So these state civil rights remedies can apply to people who work for employers that aren't covered by traditional employment discrimination laws. So in other words, people who work in workplaces where there are too few employees to be covered by Title VII or state employment discrimination laws. They also can apply when someone has been subjected to sexual harassment or assault, but they're not covered by traditional employment law's definition of who is an employee. So for example, these laws may cover independent contractors, domestic workers, freelancers. This may include restaurant workers, farm workers, workers in the so-called gig economy, or other contingent workers. They may include others in non-explicit work relationships, so people who are sexually assaulted or harassed by others in their industry, such as agents or other workplace contacts, or people in who they have some kind of workplace contractual relationship. And importantly, these laws authorize suits against an individual. So Title VII has been interpreted not to include individual liability, so you can sue the employer, but not the individual who may have committed an act of sexual assault, sexual harassment. So in some cases, that person may not be a likely defendant. They may be judgment-proof. They may not be a high net worth individual. But in some cases, it may be suitable, and your client may want to bring suit, both as a practical matter because they may have assets and they may be able to be held accountable for the harm that results from the harassment or assault, and also as a symbolic matter. Suing them may enhance a sense of accountability, both on their part and for your client. So this is really important in those cases and can fill a gap that's left particularly by Title VII. Some state laws do provide for individual liability, but usually in somewhat limited circumstances. These state laws also may apply when filing or other requirements of employment discrimination laws aren't met. So for example, if the statutes of limitation for Title VII or the analogous state law have passed, or if your client hasn't satisfied administrative exhaustion requirements. And in addition, the framing, the language in these statutes may allow for arguments that, that these laws may cover cases that may not be covered by Title VII, depending on how the law evolves and depending on your jurisdiction. So they may allow claims based on LGBT harassment, and also they may allow for arguments that harassment and sexual assault is informed by multiple forms of discrimination. So they may open the door to arguments that say harassment or sexual assault at work was informed both by, for example, gender and by race or national origin. So how are these laws framed? Can I have the next slide, please? Great, thank you. Okay, so I've identified three general statutory approaches And I want to say at the outset, big caveat, that these are not hard and fixed categories, but the categorization may be useful just for understanding them. And I also want to say at the outset that on the last slide, which I believe will be available to everyone, there's a citation to a law review article that I recently co-authored with Renee Cathawala that's out in the University of Cincinnati Law Review. And in that law review article, we detail all of the state laws. We go through the case law under each of those laws, and we have an appendix with all the statutory citations at the end of the article that I hope will be a useful tool for people. And if anyone has problems accessing it, you should be able to get it just through a quick Google search. But if you have trouble accessing it, just contact me, email me, and I'll send you a copy. So the three general approaches are laws that were modeled after the federal civil rights remedy that was enacted as part of the 1994 civil rights remedy, the 1994 Violence Against Women Act. Sorry about that. Laws that are part of a state's hate crime or bias crime law, and laws that are part of a state statute prohibiting interference with state or federal civil rights. So I'll briefly review those general approaches, and then I'll talk about the elements, which for the most part overlap. Next slide, please. Great. So a number of laws were either modeled after or enacted after the federal civil rights remedy was struck down in the case of United States versus Morrison. So the federal civil rights remedy was enacted, as I said, as part of the first Violence Against Women Act in 1994. It was struck down as unconstitutional in 2000 in the case U.S. versus Morrison. And it was the first law enacted to recognize that gender violence as a matter of federal civil rights law violates civil rights. It was enacted to provide a federal floor so that there was a remedy for survivors in every state, and to also recognize that as a matter of our federal complement to civil rights statutes, that gender violence is a form of a civil rights violation. So existing civil rights laws covered discrimination at work, discrimination in housing, discrimination by state actors, conspiracies to deprive people of civil rights, but they didn't cover the most common form of gender violence, which is gender violence committed by a private individual. Through that law, Congress recognized the value of a civil remedy that the survivor could control, as opposed to criminal prosecutions that were controlled by a prosecutor. Congress recognized the law and enacted it to redress the both formal and informal ways that state civil and criminal justices operated to deny redress to survivors. And the law was designed to provide both compensation for the harm and for the symbolic value of recognizing the nature of the harm. In other words, to recognize that when someone is sexually assaulted, the harm is different in nature from a tort. It may also be a tort, but the harm of a civil rights violation is somewhat different. So the two elements that I'll discuss more after I review the three general approaches were an act of violence, and the federal civil rights remedy defined that in terms of a federal felony. Importantly, the federal statute recognized that there was no need for a criminal complaint, charges, prosecution, or conviction in order for someone to be able to bring a civil rights remedy claim, and that carries through in the civil statutes that we'll talk about. And the other element was that the act had to have been committed, at least in part, because of the victim's gender. So the statute used the word victim. And the federal law, and this is tracked by the New York City law, it required that the act had to be committed because of gender or on the basis of gender, and due, at least in part, to an animus based on the victim's gender. We'll get to that in a minute. There were approximately 60 cases decided while the civil rights remedy was in effect. They covered both intimate partner violence and sexual assault. The case that went to the Supreme Court arose from a sexual assault on campus, but many reported decisions involved the workplace. In many cases, the civil rights remedy claim was brought against the individual who committed the harm and was brought in addition to Title VII or claims under state anti-discrimination laws brought against the employer. Now, the Supreme Court struck the law based on its conclusion that Congress lacked the authority under both the Commerce Clause and under Section 5 of the 14th Amendment. The Supreme Court majority, with Justice Rehnquist writing for the majority of 5 justices, acknowledged that Christy Brancala, who was the plaintiff in that case, alleged that she was a victim of what would be a brutal assault. And Justice Rehnquist acknowledged that, and I'm quoting here, if the allegations here are true, no civilized system of justice could fail to provide her a remedy. But then the court said, and again I'm quoting, but under our federal system, that remedy must be provided by the Commonwealth of Virginia, that's where the underlying assault took place, and not by the United States. So, that's not done with the quote now, but so a number of jurisdictions, including California, Illinois, and New York City, as well as Westchester and Rockland counties, took up that invitation and drafted laws that in large part mirrored the federal statute. So that's the first approach. Can I have the next slide, please? Second approach are laws that are part of the state hate crimes laws. So those are statutes that include gender among the categories of bias-motivated violence that the law recognizes as a bias crime or a hate crime. So those laws often provide for enhanced criminal remedies, sentence enhancements, but they also often provide civil remedies. And similar to the federal civil rights remedy, they require an act of violence, which is defined differently in different jurisdictions, and they require proof that the act was motivated by gender. So these laws typically have a list of protected identities, such as race, religion, sexual orientation, national origin, etc., and they include gender. Next slide, please. The third approach are statutes that prohibit interference with state or federal civil rights and include gender, or the right to be free from gender violence, as one of the civil rights that could give rise to a civil claim. These laws often specify that the law applies regardless whether the person committing the harm was acting under color of law. So they explicitly apply to private individuals. And in some cases, these laws reference other parts of the state statutory scheme, for example, the state civil rights laws, human rights laws, or employment discrimination statutes. So now I'll talk a little bit about the elements. Can I have the next slide, please? Great. So as I said, the elements generally are an act of violence and that the act was gender motivated. The statutes of limitation vary. They may be long, but it can be really useful to know that they may be longer than employment discrimination statutes. So for example, the New York City law and the Illinois law both have 7-year statutes of limitations. Now I will say that there's some case law out there, at least in New York City, questioning that case law and whether or not that statutory provision is preempted by state laws, but at least an issue to flag to research in your jurisdiction. And also, as I said earlier, there likely will be no administrative exhaustion requirements. Can I have the next slide? Great. So how do the statutes define an act of violence? This slide gives you some of the examples. It's not exhaustive, it's illustrative. It should give you an idea of the range of definitions that the statutes use. So of course you have to check your state laws. It's important to carefully check the state's definition. Under the federal civil rights remedy, a number of decisions rejected claims on this basis. So, for example, that law required proof both that the act rose to the level of a felony and that it would meet the requirements of a federal statute that required the use, attempted, or threatened use of force. So some allegations of inappropriate sexual contact in a number of different contexts, sexual assault by a priest, unwelcome touching by a psychiatrist, were rejected by courts on that basis. So important to check the definition, but really importantly, just about every law specifies that the civil cause of action is available regardless of whether there's a criminal prosecution or a conviction. And I should say that generally the statutory definitions of violence in the state statutes are less exacting than those in the federal civil rights remedy. So a wider range of violent conduct should be able to be the predicate act that gives rise to a civil rights claim. Next slide. Great. So the next element is that the act be motivated by gender. Some of the laws refer to this as gender motivation. Now, I'll talk about the most difficult to prove first. So some of these laws, for example, the New York City law that I know that Ilan and Zoe will talk about more, mirrored the federal civil rights remedies requirements and included a two-part definition that required that the act be have been committed because of gender or on the basis of gender, and due in part to an animus based on the victim's gender. Now, while it was in effect, while the federal law was in effect, virtually every court that was faced with any non-frivolous allegation of sexual assault, sexual harassment, or intimate partner violence recognized the violence as gender motivated. Commentators had worried about the ability to prove that the act was gender motivated. But the case law really followed Congress's direction to treat these claims as they would treat other allegations of discrimination, and to look at the totality of the circumstances, to treat the definition as a single element, and to look at things such as epithets, patterns of behavior, comments, and to analyze like they would the bias here, like they would analyze bias in other anti-discrimination statutes. The legislative history was really clear that the two-part definition was meant to ensure that only gender-motivated acts, and I'm going to put this in quote, not random acts of violence, I'm quoting from the legislative history there, could give rise to recovery. And so there was a concern about all acts of violence within families, within intimate relationships, giving rise to claims. And so this two-part definition was intended to ensure that there was some indication of some discriminatory motivation that underlay the act. Can I have the next slide? Great. So in the federal law and in some of the state statutes, the word animus is used. And here the VAWA legislative history, the Violence Against Women Act Civil Rights Remedies legislative history, should be helpful and is really clear that the term was not meant to require proof of hostility, animosity, or ill will, but that instead it was included to refer to the body of case law under 42 U.S.C. 1983 and under Title VII that directed courts to make sure that the act was in fact related to, due to, the victim's gender. It was also included to make sure that disparate impact claims could not be brought. Now, there's some troubling case law under the New York City law that Zoe and Ilan, I think, will talk about, suggesting that this definition requires proof of animus toward women. But that decision ignored the Violence Against Women Act Civil Rights Remedies legislative history. It relied on misplaced authority. And what I'll just say about that case now is that it highlights the importance in litigation of distinguishing discriminatory motivation from the more colloquial use of the term animus, which could be interpreted to mean hatred. Okay, next slide, please. So what I've included in these next few slides are just examples of cases brought both under the federal civil rights remedy, the Violence Against Women Act Civil Rights Remedy in workplace claims, and then the next slide, Title VII cases finding that allegations of sexual assault were committed because of sex. So you should have these for reference. They're illustrative, again, not definitive, but they illustrate how courts readily recognized that workplace harassment, such as an employer's fondling or attempting to remove an employee's clothing or grabbing her breasts, were gender motivated. Another case found that a male supervisor calling a female employee a, quote, dumb bitch, close quote, and later shoving her to the ground was gender motivated. Or that inappropriate sexual remarks and unwanted touching from a chiropractor of his employees also was gender motivated. And there was some interesting language in that case where the court said, quote, regardless of the amorous intentions of the perpetrator, non-consensual expressions of affection that rise to the nature of those alleged in this action are laden with disrespect for women. And the court recognized that that would satisfy the element. Okay, the next slide, please. So these are, as I said, Title VII cases finding that allegations of sexual assault were committed because of sex and therefore violated Title VII. These may well be familiar to you, and I'll just highlight, because this can be useful in the state civil rights remedy cases, that the Supreme Court in 1986, in the case of Meritor versus Vinson, readily recognized that, of course, was a case of sexual assault, and the court readily recognized that, quote, without question, when a supervisor sexually harasses a subordinate because of sex, that supervisor discriminates on the basis of sex. And many other cases have recognized that even a single act of rape in the workplace may constitute impermissible sexual harassment. Of course, it's important to research your particular facts, your jurisdiction, because some courts more recently have narrowly interpreted the requirement of sexual harassment law and have reached some differing conclusions about whether a single act could be found to be because of sex in violation of the statute. Next slide, please. So finally, some notable case law from around the country under the state civil rights remedies. So I highlighted a case from California against a Starbucks supervisor who allegedly coerced a minor barista into repeated sexual encounters. There was a case, a gender violence claim against two male coworkers who touched a male employee in an offensive manner, so showing that these laws can be used in same-sex harassment cases. There was a claim of a class of employees who worked at a nightclub who alleged lewd touching and unwelcome sexual advances from their supervisor. There was a claim by a secretary against an Army major that he had sexually assaulted her. So a range of contexts showing how these laws can be used. But I think what's most notable is that despite the fact that many of these laws have been in effect for many years, many of these laws were in effect even before the 1994 Violence Against Women Act was passed, there's very little case law reflecting their use. So what this means is that there's an opportunity for advocacy that reflects the nature of the harm, the nature of your client's experience, the context, the cultures of impunity that often fail to hold individuals and employers accountable. And so while these laws won't be useful in all cases, they are tools that I think could be more widely used, more widely publicized, and I hope that particularly now with increased awareness of the problem, they could be used in a range of settings to help provide compensation for survivors and to help eliminate gender violence as a form of impermissible discrimination. So the final slide is just some resources as promised. And with that, I'll say thank you and look forward to your questions.
Terrific. Thank you so much for that presentation. That was excellent. Now we are going to go to the next portion of the webinar, which is going to be me asking questions to Blanca, Ilan, and Zoe about their experiences applying claims like this in their practice in New York and in California. So I have a list of questions. We're going to see how many we can get in. I was thinking that we would do this until about 3:15 and then allow time for questions from our audience. So I'm going to begin having each of you explain to us what state or local laws exist in your jurisdiction to challenge gender violence at work. And if we could start with Ilan and Zoe.
Okay, great. Well, this is Ilan Mazel, and thank you so much for having me on this webinar. And it's a great honor to be part of the Legal Network for Gender Equity. You do incredible work, and it's just great to be a part of it. Here in New York, we are in New York City. We have state and local laws that address gender violence at work. And maybe we'll just start with the general anti-discrimination laws available under state and city law, which would apply, in addition to the Victims of Gender-Motivated Violence Protection Act, which applies in New York City. So we have both a state and a city anti-discrimination employment statute, the New York State Human Rights Law, the New York City Human Rights Law, both of which prohibit discrimination on the basis of many protected categories, including sex, at work. The state human rights law applies to any employer that has 4 employees. The city also to any employer that employs 4 employees, except that as a result of a recent law by the City Council a few months ago, in sexual harassment cases, you only need 1 employee to be liable for sexual harassment at work. We'll discuss perhaps the elements of some of these claims later, but in brief, they prohibit any sort of discrimination on the basis of sex, which plainly would include any gender-motivated violence by an employer. In New York City, we have a very broad anti-discrimination law. It applies both to employers and to employees. It applies to any employee who has managerial or supervisory responsibility, or who knew of an agent's discriminatory conduct and failed to take immediate and appropriate corrective action, or who should have known of the discriminatory conduct, in this case, the gender violence, and failed to exercise reasonable diligence to prevent such discriminatory conduct. So a pretty broad statute. In addition to those basic anti-discrimination laws, we have the Victims of Gender-Motivated Violence Protection Act, which was passed by the City Council, applies only in New York City. It is of the variety that Julie was just describing. It's one of those laws that was intended to fill the gap after the federal statute was struck down by the Supreme Court. That prohibits gender violence at work and anywhere. And maybe we'll talk briefly later about exactly the elements of that claim. In addition, of course, we have the old-fashioned common law assault and battery claim, which certainly applies to gender-motivated violence that rises to the level of an assault and battery, or, of course, any violence that rises to that level. So I think that's just a brief summary of the statutory background in New York City and New York State.
This is Blanca. Thanks, for inviting me to this. For California, so California Rural Legal Assistance practices in rural California, which covers the most conservative parts of the state. So we are not talking about, Los Angeles, San Diego. We are not talking about the Bay Area, including San Francisco or Oakland, but the most conservative parts of California. And because of that, there are no local protections in the communities we practice. As such, we rely on either Title VII or California's equivalent, which is the Fair Employment and Housing Act, to file claims on behalf of our clients regarding gender violence in the workplace. We also use tort claims such as assault and battery, intentional infliction of emotional distress when applicable. And it usually applies when you're talking about gender violence. But in a nutshell, those are the laws that we are dealing with in rural California.
Thanks.
Actually, I'm sorry, one other thing I want to address now as well is under FEHA, which is the state equivalent of Title VII, like New York City, the employer only has to employ one employee to be found liable under the FEHA. So in a lot of our cases that, your client might be the one employee to be covered under FEHA.
And Blanca, FEHA, do you mean Fair Employment and Housing Act?
Yes.
Thank you. So Blanca, maybe I will ask in reverse order this time. I'm going to have you answer this question, and then Ilan and Zoe. tell me what terminology your state statutes and courts use when discussing workplace gender violence, and how do the statutes and courts define those terms? So some states use terms like gender violence, others rely on sexual assault, sexual harassment. What's the case in California? Talk to us a little bit about that.
So in our experience, the courts use the term sexual harassment. That's very common to hear in the courtroom. And then depending on the type of sexual harassment, we will either be discussing quid pro quo, which is, adverse employment action resulting from an employee's refusal to accept a supervisor's demands for sexual favors, or hostile work environment, which is more like unwelcome conduct that is either severe or pervasive, and that is sexually offensive. So when we're talking about sexual harassment in the courtroom and in front of a jury, those are the terms that are usually being used: sexual harassment, sexual assault, and potentially we would be arguing workplace violence, but the term of art used in the courtroom is typically sexual harassment. You also hear discrimination based on sex, which is also used a lot, and this, in my opinion, can be somewhat confusing to juries, which at the end falls on the attorneys presenting the case to ensure that the jury understands that sexual harassment and sexual assault falls under what is considered sexual discrimination based on sex. And so those are the terms we're hearing here in California. And they are terms of art. And I think, as Julie was talking about earlier about the term animus, that is something we have to ensure juries understand, because here when we're talking about, for example, the word intent, a jury may believe that there has to be this personal intent, personal hatred to do harm. And if the jury doesn't quite understand what we're talking about, we could be in trouble when it comes to filling out the verdict forms.
Okay. Zoe, since we haven't had a chance to hear from you yet, tell us what the situation is in New York State and New York City. What kinds of terms do the statutes and courts use to address workplace gender violence?
Thanks, Jennifer, and I'll join Alan and Blanca in just thanking you for coordinating this panel and for all the great work you're doing with the network. So in New York, we have both paradigms. We have the more traditional sex discrimination paradigm that Blanca was just describing. And the one thing I'll point out there about New York law is that there's a very big difference between how the New York State human rights law defines sex discrimination and how the New York City, the local city human rights law defines it. In particular, the City Council had an intention when it passed the city human rights law to provide a much broader remedy than was available under federal law, Title VII, or the New York State human rights law, which the courts have interpreted to really track Title VII. And those, the courts have interpreted the state law to be analogous to Title VII in virtually all respects. But the City Council was very clear that it wanted the city human rights law to be broader and to prohibit a broader range of conduct. So in the sex discrimination context specifically, the courts have held that the requirement of severe and pervasive to establish a hostile work environment claim, which exists under federal and state law, does not exist under the city human rights law. That is too restrictive, the courts have held, to satisfy the legislative intent and the statutory language the City Council used in drafting the city human rights law. So the courts have held that under the city human rights law, even one sexist or sexual comment at the workplace could suffice to plead a hostile work environment claim, which is very different from the standard under federal and state law. Obviously, gender violence is at another level from a single comment being made. And there, I think even under federal and New York State law, most courts would hold that an act of gender violence at the workplace suffices to establish a hostile work environment. But I think it's important to note that with respect to our local city law, it is a broader standard and the courts interpret it so. We also have in New York, as Alon said at the beginning, a very specific statute called the New York City Victims of Gender Motivated Violence Protection Act. And that statute does use the language that Julie was summarizing in her presentation. It provides a private right of action for any person claiming to be injured by an individual who commits a crime of violence motivated by gender. So we'll talk, I think, in a moment about, unpack what the elements of that claim are. But that is in some ways broader and in some ways more narrow than the human rights paradigm. It requires a crime, which, a lot of sexual harassment does not rise to the level of a crime, or especially a crime of violence. So in that way, it's more restrictive. But as Alon mentioned, it does not require an employment relationship. So in that way, it is broader. And I'll be happy to unpack a little bit more how the courts have interpreted the elements of that claim. Should I do that now, Jennifer? Or do you want to ask another question first?
Great. Well, we had talked about having you all walk through elements of the claims and remedies available and that sort of thing, and I'd like to do that, but it strikes me that you all have really interesting stories to tell about cases where you've used these claims, and I'd love to make sure that we have time to hear about that. So I'll start with you, Elon and Zoe. I know that you've had some fairly recent success using some of these laws in cases involving workplace sexual violence. Can you talk to us a little bit about what successes you have had, and to the extent you can tell us a little bit about that case?
Sure. So, of course, many of the cases we've had we can't talk about, unfortunately, because they're confidential for various reasons. But one case that we litigated recently and are litigating right now is Haley Breest and her case against a Hollywood director named Paul Haggis. And I should emphasize this is an ongoing case, and all of her claims are allegations at this point. They've not been proven in court. But she has alleged that that this defendant sexually assaulted her in his apartment. This is not a workplace claim per se, but it does use the Victim of Gender Motivated Violence Protection Act in the similar way that we would use that claim in the workplace. It's a very interesting case in multiple respects, not the least of which is that we had a motion to dismiss, which challenged us to prove, to make the allegation sufficient to allege this claim. How do we show that his acts were gender motivated? It wasn't that difficult to allege that this was violence, but how do we show it was gender motivated, and how do we show there was animus? Some of the allegations we made and that the court considered were the very fact that he sexually assaulted her, as she alleged, the comments that he made during the assault, and an alleged history of sexual assaults of other women. And the court held, as other courts have held, that all of those are factors ultimately for a jury to consider in evaluating whether there was animus and whether this was gender motivated violence. Of course, one of our arguments was that any sexual assault, certainly any rape, is per se a violation of this act, that it has to be gender motivated violence if it's a sexual assault. The court did not have to reach that issue, but it's certainly our strong view that that is the case, and there are cases that stand for that proposition, and other cases that perhaps don't stand for that proposition. So interesting ongoing case in the middle of discovery, but that is one example.
Another example I wanted to add, this is Zoe, that our firm is also in the midst of ongoing litigation over, is a case we filed last year in the New York City Commission on Human Rights. So in addition to having a very broad local city human rights law, we have a local city commission that was established to enforce that law. You can choose to bring your claims under that law either in court or in the commission. And the case that I'm describing now is called McElrace versus Wegman Partners. It is an employment case involving our client who was employed as a legal recruiter in a legal recruiting firm here in the New York City area. And as with the Breest case, this is an ongoing case, and these are all allegations at this point. But she alleged that her supervisor, who ran the New York City office, made, I mean, it's kind of incredible how much he did in a short span of time, but made various offensive comments and remarks to her, and also grabbed her sweater and tried to grab her breasts. So in this case, our client, Ms. McElraith, like a lot of employees in America now, had an arbitration clause in her employment agreement, which would have, in our view, allowed defendants to argue, if we brought the case in court, that the case should be referred to arbitration. And this company had selected arbitration in another state, not in New York City. And we were obviously concerned that an arbitrator in another state would not be familiar with our broad New York City laws. So we chose instead to file the case, rather than going to court or to arbitration, we chose to file the case in the New York City Commission. And I raise this case because I think that city and state agencies are often overlooked in bringing these cases, and sometimes for good reason. Our New York State Division of Human Rights is generally thought to be a very ineffective body to bring claims as a plaintiff. But the New York City Commission is different, and the Commission has taken the view that its authority to act cannot be circumscribed by private contract. And so it has statutory authority to investigate and prosecute acts of sexual harassment and other employment discrimination, even if the employee has signed an arbitration agreement. And what's very special about our New York City Commission on Human Rights is that it has the power to investigate and prosecute violations, as well as to award compensatory damages, just like you could get in court. So I raised that just to flag as a practice tip that I think it's important with these cases, and I think we're going to be talking about this throughout the panel. You know, there are often challenges with arbitration clauses, with statute of limitations, with you know, the elements of particular claims and how you're going to prove them. And I think it's really important to look, as Julie was saying in her presentation, very carefully at your state and local remedies that are available, and to think outside the box about, in a particular case, which ones you might elect to best serve your client's goals.
And this is Blanca. I'm going to talk briefly about two cases where, you know, we were successful. They're two completely different cases, just to provide, you know, different examples. So the first one I'm going to talk about is a case that we filed on behalf of two women farm workers who were packing celery between 2007 and 2011 for a company called Jackpot Harvesting. The case had actually initially been filed with the EEOC, and after an investigation that took years, right, EEOC decided not to litigate, and so we ended up filing on our own. You know, the facts of the case, so this case is out of Monterey County. The facts of this case in a nutshell are that one of our clients, who at the time I believe was 18 or 19, had been raped by her foreman. And he raped her off of outside of work hours, off of company property. And then the second client was another coworker who had been a victim of the hostile work environment, right? So she would see this foreman engage in certain, you know, conversations with coworkers, maybe walk by and pat women, you know, whether it be the back or their shoulders or you know, anything. And so we had those two clients, and then we went to jury. We handled the jury trial. We did have experts. We had our expert who evaluated our clients, but especially with the rape, the client who had been raped, it was really important for us to be able to demonstrate why she was going to testify the way she was going to testify, right? Why she wouldn't necessarily remember, you know, all the details of her rape. Why she, what she would remember were smells. If she saw, for example, a broken piece of glass on the floor when she was turning away, that's something she would remember versus, you know, maybe what he was wearing. The other thing that was very helpful about our expert is that both of our clients were monolingual Spanish speakers. Our expert also speaks Spanish, so he was able to conduct his examinations in Spanish and interview our clients directly in Spanish. The defendants hired their own expert who did not speak Spanish and who chose to use a certified interpreter. The interpreter actually told him that his questions could not translate properly because of context. For example, if he was using certain English language idioms, the interpreter would tell him, these don't translate properly. If I ask this question this way, it's not going to make any sense. And, the expert was actually tape recorded, so his response was just translate. And so that was really important for us to be able to point out to the jury. And then ultimately, the jury found in favor of our clients, which was a huge victory because the client who had been raped had not reported it to anybody, to law enforcement, had not reported it to her family, had not told her colleagues. The first time she told anybody about it was when she came to our office, which was, I think, almost a year after she had been raped. And so after the jury found in favor of our clients, the defendants decided to make a settlement offer, and we settled the case right after the verdict for $1 million. And then on top of that, the company agreed to adopt additional workplace policies to attempt to prevent sexual harassment of farm workers in the future. So that's, definitely a success. A lot of work, a lot of lessons learned as well. And then the other case is a case we filed with the Department of Fair Employment and Housing, which is, this California equivalent of the EOC. We also filed a National Labor Relations Board complaint on behalf of 5 women who were enduring sexual harassment in the workplace daily. These were 5 workers who were sorting nuts in a little town called Salida, California. The facts supporting the complaint were that their coworkers and supervisors were frequently talking about sex, bringing sex toys into the workplace, having sex parties at work. So they would play with their toys during, their lunch breaks or the rest periods. Our clients complained about it to management, were immediately fired and escorted off the property by police. We ended up representing them in these administrative complaints. The workers were offered reinstatement. Confidential settlement was reached in that case, and 3 of the 5 workers decided to return to work, which I thought was powerful, right? I would tell my clients, like, when you go back to work, everybody knows you were escorted by the police, but who's back? You're back because you won. And so I thought that was really important to ensure that other workers were getting that message. And that settlement was confidential, but, in California, we're lucky enough that SB 820 was signed by Governor Jerry Brown, and effective January 1st of 2019, secret settlements in sexual harassment cases are prohibited, and employer cannot require a non-disclosure agreement as part of the settlement.
Thank you for that. Those are terrific examples. I'd like to ask each of you to talk a little bit about what factors you consider when evaluating whether to bring these kinds of claims in a particular case. Talk to us a little bit about what are the benefits and what are the risk factors of bringing these kinds of claims for the types of clients that you typically see in each of your firms. And I will turn it over to Ilan and Zoe to answer that question first.
Okay. Well, the first factor is pretty obvious. Has the statute of limitations run? And I'll say in this Me Too era, there's so many people who've come forward about conduct that happened 10, 20, 30, 40 years ago. And so the first question is there some possible claim within some statute of limitations that we can assert? For example, the New York City claim, the Victims of Gender Motivated Violence Protection Act, statute of limitation there is 7 years, which is longer than the city or state human rights law. And that's powerful. That captures a lot of conduct that we couldn't otherwise capture through other laws. So that's the first point. Obviously, it's very, very important to really get to know the client. Is this potential plaintiff credible and believable, and how will this person fare in front of a jury, hold up on cross-examination? That's always very important. I always believe that the most important person in any civil rights case is the plaintiff. If the jury believes and likes the plaintiff, that our chances of winning the case are extremely high. What is the corroboration? Are there text messages? Are there emails? Are there voicemails? Are there witnesses? First of all, they're witnesses to the actual underlying conduct, which often is not the case. But if there are, that's extremely powerful. Are there outcry witnesses? Are there witnesses to whom the victim spoke and said, "This happened to me," contemporaneously? That's important. An analysis of the defendant. Who is this person? Will this person be credible and likable before a jury? Has this defendant been engaged in a pattern of misconduct towards others? Is there a pattern of sexual misconduct? Are there other victims? Often we don't know that at the beginning, but we learn that throughout the course of the case. That's extremely important to evaluate. And of course, for a gender-motivated violence claim, is there actual violence? Is the conduct sufficiently severe that it falls within the statute? And as Zoe mentioned before, there are certainly acts of sexual harassment that don't rise to the level of gender-motivated violence. So those are, I think, some of the things that at least I'm looking for in evaluating these cases. And I'll let others jump in.
This is Blanca. I agree with Alon. I think you've hit pretty much everything we consider. I would also add resources, right? Does, CRLA, California Rural Legal Assistance, is a nonprofit, so we do have to consider the resources we have to take the case if we choose to take the case on our own and file it, and so that is a big question for us because it does require a big investment of resources. Because of that, sometimes, we will also consider, is this a good case to pitch to private co-counsel to work the case with us? Or in some cases, if we say we don't have the resources now, we may have them in 3 months. Let's make sure we file a claim with the state agency or EEOC. That way that'll give us some time to get some free discovery through their process and also give us time to prep for the litigation. And I would just echo the client, making sure you have the right client, because at the end, this is a really long process. Our clients will likely be re-traumatized, as they have to testify about what happened to them in depositions. They will have to testify to it, in the courtroom, and they have to be ready to be attacked, in different ways, right? Our clients are low-wage workers, so they are, it quickly becomes easy, in our experience, for the employers to attack our clients by saying, because they're poor, your client was a prostitute. She wasn't raped. She agreed to have sex. For many, because there is no money trail, right? They weren't actually prostituting themselves, but that is a very common defense with low-wage worker women. I would also say we get to, we are dealing with sexism, but on top of sexism, we're dealing with classism and racism, right, when you're talking about low-wage workers. And so taking all that into consideration, right, if you have a monolingual Spanish-speaking client, you need to think about interpreters. How is that going to, play in front of the jury? Because we have had juries who have issues with interpreters, so you want to make sure you're asking the right questions during jury selection. But yes, I think that's it.
Blanca, you touched on some of the defenses that get raised in your cases and also some of the challenges that you face in bringing these kinds of cases. Are there other common challenges that you see when bringing cases, particularly under the state laws that you've been talking about today?
I think so. In a lot of these cases, it is your client's word versus, employer's word. So credibility is huge. The other things is juries seem to expect that a sexual harassment survivor maybe behave a certain way. So frankly, if your client cries too much, they might be seen as faking it. If they don't cry, then they must have not been raped. So again, important to retain an expert for that. I would also add something we have come across as well is because a lot of our clients are immigrants, is the employer will bring up immigration status. And so given the, current political climate, there may be a lot of, animosity against, immigrants. And so even if your judge says immigration status is not coming in, the defendant, at least in my experience, opposing counsel has usually tried to at least plant the seed in some very bizarre way, by trying to get as close as possible to bringing up immigration status without crossing the line in front of maybe the judge. So I would say if your client is undocumented, this would be a completely separate training talking about the potential of getting a U visa, right? Is something you also need to consider whether you want to do that before you file the lawsuit. Do you want to wait until after the lawsuit is filed to apply for a U visa, because that will come into play. The other defense I've seen is they want to, get legal status. That's the only reason they filed this, and they're also trying to get public benefits or victim benefits from the state. So those are some of the things I've seen from employers.
So in New York, this is Zoe. In New York, in our practice, we represent a real range of clients. And because we're in New York City, none of them are agricultural workers like Blanca's clients, but we do represent blue-collar workers like security guards and waitresses, as well as more quote-unquote white-collar workers, executives, and mid-level professionals and managers. And what's striking about, I think, the fact that our clients are very different from Blanca's is that we are running across a lot of the same challenges and defenses. So the number one defense we hear in cases of sexual harassment or gender violence is a two-pronged approach: deny whatever you can, and for the rest, claim that it was consensual. And even in the Me Too era, it's really surprising how pervasive those themes are. The denial, I suppose, is not surprising. That's typically how defendants respond to lawsuits. But the theme of consent is really deeply rooted in our society, I think. And we have had, just in this last year alone, defendants argue that our client was, quote unquote, the provocateur, in their words. And they hired an expert to testify that she was the provocateur in the relationship that was going on with her boss. And so you see this theme, I think, really coming across all of these cases. She asked for it, she wanted it, she initiated it. And I think there's a lot of work to be done educating juries and judges and arbitrators and mediators on the power dynamics that underlie all of these cases. Whether it's sexual harassment or gender violence, there is always a power relationship, whether it's a boss or a more powerful coworker, a client, someone who you perceive to have a lot of influence in your personal or professional life, and who holds a lot of sway over you. And so I think that's something that, we are struggling with in all of our cases. And we're seeing, I think, even in the Me Too era, some very aggressive claims from defendants along those lines, and also, even more going to the point of going on the offense against our clients. And some of this stuff has been publicly reported, but you see defendants accused of rape or sexual assault or sexual misconduct looking for their own affirmative claim to bring against the victim. So in the case that Alon mentioned earlier, Breest versus Haggis, Mr. Haggis brought a claim against our client for intentional infliction of emotional distress, alleging that her raising her allegations caused him to experience severe emotional distress. And we were lucky enough to have a smart judge who applied the law and dismissed that case earlier this year. But I think that is something we're seeing more of. There's backlash against the Me Too movement with men who think that, the best defense is a good offense. or is that the other way around? But who are coming out very offensively against these women, not just denying, but actually attacking them in every way they can, their credibility, their personal lives, and if they can, legally. So I think that goes to Blanca's point about working with your client. You know, there's a big concern about, is your client credible, likable, but also, can she handle this? Can she handle a long litigation where they will, you know, do whatever they can to undermine her, to drag her through the muck? Can she withstand that? Is she getting good mental health treatment that will, you know, provide her with that sort of support that, you know, we as lawyers just aren't qualified to provide? And is she prepared for the fact that in this day and age, for better or for worse, there's often a lot of publicity surrounding these claims? Is she ready for that? Because that takes a whole other toll on victims and plaintiffs who come forward. So those are some of the challenges I think we're grappling with in our practice.
That's so interesting. Thank you all for sharing that. I'm going to ask one more question and then leave time for questions from our participants. So this is my plug, folks listening on the line. If you have questions, send them to us through the chat function on the side of the screen, and we can ask them to our excellent panelists. If not, I'm going to keep going with my questions because I have a lot of them, and we have these terrific panelists. So the next thing I wanted to ask all of you, building off of what you were just talking about, is if there are strategies that you have used successfully to make it more feasible to bring these types of cases. What kinds of things have you used to fight back against some of the challenges and the defenses that you were just talking to us about? And we'll start with Blanca.
So I think one of the strategies we've tried, and it's not necessarily, you know, litigation based, but I do think it's important to continue to do more outreach and education, right, to workers, because if workers are not informed of their rights, they will not know to seek legal help. You know, we need to ensure that outreach and education is conducted in languages that workers understand as well. And I think, you know, having these conversations with your clients are important. And then if you're doing outreach and education, which I know not necessarily, most attorneys don't do that, but if that is part of your practice, you know, I think at the end what we're trying to do is make a change in our culture. And so it's not going to happen, you know, overnight. But I think, you know, for example, when I've conducted presentations, I've had some workers maybe ask me something along the lines of, so now I can't give a woman a compliment. And I'm usually quick to respond, no, you can't. You are in a workplace, despite what that type of work is, whether it's a field, whether it's a restaurant, whether it's an office, it's a place of business, and you should treat your coworkers with respect. So you know, I think we should not hesitate in calling things out. But as far as strategies in our lawsuits, we frequently do co-counsel with private firms. At times, we pick and choose cases to file straight in court or litigate with either the Department of Fair Employment and Housing or EEOC. And the reason I think, for me, it's always been tricky whether we want to join forces with the government because there are pros and cons. I would say the pros are, in an investigation, you know, you're getting free discovery, you know. Well, you'll get it at the conclusion of the investigation. The government agencies can usually enforce subpoenas, you know, without having filed a lawsuit yet. Both, you know, DFVH and EEOC also have voluntary free mediation procedures that can result in early resolution of a case if that is what your client wants, right? If your client prefers to try to resolve this quickly, that is definitely something we should take advantage of when we are partnering with government agencies. As far as litigation and partnering with government agencies, I would say they can file as a class action without meeting class action requirements. So that is, you know, definitely a benefit. The government may have more resources than maybe private practitioners or the nonprofit, right? And frankly, the fact that the government is involved can mean a lot to a jury. I think, you know, when it's state of California versus, you know, ex-employer, that means a lot to a jury. And they also, in my experience, government agencies have more experience in obtaining injunctive relief. And that is really huge, right? Because if at the end you're not only trying to recover something for your clients, but you want to have a workforce-wide impact, then that's one way to do it. Understanding the cons with working with government agencies is, you lose control of the case to a certain degree, because the interest of the government is the government, and that's their client. So it's not necessarily, they're not necessarily looking out for your client in all cases, and sometimes there may be some tension there. If they're going to settle the case, they may or may not talk to you. So I think it's important that if you are going to be partnering up with the government agency, that you talk to them beforehand and try to set some ground rules. And although you can intervene into the lawsuit, I think what's most important at the end is having established rapport and a strong relationship with the government agency to reach a good result for your client and hopefully make a change on a workforce-wide basis.
This is Alon. I'll just jump in. First of all, I agree with absolutely everything that Blanca just said. And I think a couple other things that we would do in a case like this is, first, really have a heart-to-heart with our client. We gird them and prepare them for what they're in for, because as Blanca mentioned before, and as Zoe mentioned before, this is a very difficult process. Their mental health records will be reviewed. They will be examined every which way, in the deposition, at trial, if there's a trial. So we really need to prepare our clients for what they're in for, and know, of course, let them know that we have their back, that we will be fighting for them every single step of the way, but that this is not going to be easy. And sometimes that also involves helping the clients get help, getting mental professional involved potentially, because of course many of our clients are really hurting and they need help, and many of them don't have it, and maybe don't even know where to find it. So that's something else that we would often do. Of course, all the traditional things in preparing for a case, speaking with witnesses, potentially investigating the defendants, gathering the evidence, that's all extremely important. And one other thing which I think is not to be minimized is letting the defendant know that we are going to fight for our client to the very end, no matter what, that there is absolutely nothing they can do to deter us from fighting for our client until we get the result that we believe our client deserves. And defendants need to know that. They need to know that no matter what tactics they employ, no matter what frivolous counterclaims they come up with, no matter what defenses they come up with, we are going to fight this to the very end. We're not just in it to get some easy settlement. This is going to go to the very end unless they come up with a result that's acceptable. And I think that's a very important message to the defense counsel, and that's something that our clients also need to see us doing. They need to see us fighting for them, because often they've never had anyone fight for them, and we're the very first people that are fulfilling that role. So zealous advocacy, nothing like that.
That's great. Thank you all for those answers. You are practicing in very different parts of the country, but we probably have folks on the line who are in states between California and New York. I'm wondering if you all can speak generally about what advice you would give to other attorneys who are thinking about bringing state law claims for situations involving workplace gender violence, and who maybe haven't thought about bringing those kinds of novel claims before. What kinds of advice would you all give to those folks? And maybe I'll turn it back to Blanca first.
So I think, in a nutshell, be ready for war. These cases are righteous, but not only are they emotionally draining on your client, they can become emotionally draining on the attorneys as well. And I think that, you should, and even though we've talked about, prepping your client for all of this, I do believe there is some silver lining as well. So, I tend to be, a pessimist, but I do think, at least in my experience, I've seen my clients, whether we win or lose, I've seen them become more empowered through the process. We recently had a case where we lost in front of the jury. And the jury, you know, after I spoke to them, told me, yes, we believed she was raped, but the employer, the guy who raped her, which was the grower, he didn't understand he was raping her because of his culture. In his culture, if a woman doesn't say no, she's not being raped. So she didn't use the magic word no. But seeing her, this client, right, in the courtroom, you know, opposing counsel at some point said something along the lines of, started a question by saying, I know this is embarrassing, and he was actually going to get into her having a miscarriage, and that's what I'm talking about, right? Like, they're going to get into everything. So he was getting into her having a miscarriage, but he started the question by saying, I know this might be a little bit embarrassing. And her response was, I'm not embarrassed about anything. I've done nothing wrong. If anybody has to be embarrassed, it's you and your client. So to me, that was one of the most powerful moments in the courtroom, because I felt, win or lose, she's already begun her healing process. She's begun her empowerment process. And so I think that's something we should consider. And that's the advice I would give attorneys, like, be ready for war. And then also remember that, yeah, you're trying to recover, you know, money and maybe injunctive relief, but, you know, you are also hopefully helping your client with the healing process.
So this is Zoe, and Blanca's story reminds me of a moment I just had recently with a client, and she was asked at the hearing by defense counsel about her menstrual cycle. And just like Blanca's client, she looked him right in the eye, and he was definitely trying to embarrass and intimidate her. And she looked him right in the eye and said she had had a miscarriage. And that was the end of that. But I think, you know, it just does go to show what lengths they will go to. This case had nothing to do with her menstrual cycle or, you know, potential pregnancy. That was utterly irrelevant. But they will go there. So I think in terms of preparing, we said it all, but just to sort of pull it together, I think that the starting point is, what laws do you have in your state and jurisdiction, county? Sometimes in New York, at least, we have county-wide laws that can be very good and useful, or your city laws. What are those laws? And as Julie said in her presentation, some of these laws are really underutilized. And so for the New York City Gender Motivated Violence Protection Act, there are literally a handful of cases that have ever been decided, at least that we could find any record of. I'm talking about, I think before our case, 3 or 4 cases under this statute, and which has been on the books since 2000. So for whatever reason, lawyers are often not pleading these claims, and judges, I think, are often coming down on them. At least in New York City, there were, as Julie alluded to, in the past, some very bad decisions from judges who really didn't read the law very well, who perhaps weren't educated by plaintiff's counsel about the legislative history and purpose of the law, who weren't, you know, suggested by plaintiff's counsel to go read the underlying cases from the VAWA period from the federal courts, implying very similar legislative history and statutory text. And so our case, Brees versus Haggis, is, as far as we know, the only case under the New York City Victims of Gender Motivated Violence Protection Act to survive a motion to dismiss in the statute's 20-year existence. So that's really unfortunate. And a big part of our goal in doing this training and speaking out generally about this case and that act is to encourage more lawyers to bring the cases. And when you do bring the cases, to very thoroughly investigate before you file. Investigate your client, investigate the defendant, speak to the witnesses, gather the emails and texts and medical records that are going to be your evidence to make sure that you are ready for the war that is coming, as Blanca said. And so I think that it was a combination of creative lawyering, thinking outside the box, really drawing on statutes. If something wrong has happened, at least at our firm, we want to find a law that will allow our client a venue with a timely claim that can give her some real relief. And oftentimes those laws are out there, even if they're not your typical employment discrimination or, you know, assault and battery claims. So to think outside the box and then to very robustly, you know, investigate your allegations before you plead them in court. And then finally, if you are bringing a claim under at least the New York City Victims of Gender Motivated Violence Protection Act, but I suspect under similar underutilized local statutes, you have to plead it very robustly. In our case, you know, as Alon said, the court really looked to all of the pleading. The fact that we alleged in the complaint that there were derogatory sexist comments made, the fact that we alleged sexual violence, the fact that we alleged that the defendant had a pattern of sexual violence and misconduct. If all of those facts are true, you should plead all of them in your complaint in an effort to make as robust a showing as possible and avoid that motion to dismiss.
That's great. Elon, do you have anything that you want to add, some general advice to give to folks thinking about bringing these kinds of claims?
Well, what could I possibly add to what we just heard from Blanca and Zoe? I mean, that covers it. I mean, we need to know the law, we need to know the facts, we need to prepare the client, and don't hold back. I mean, you know, 42 U.S.C. 1983 was on the books for something like over 70 years before someone finally came around and said, oh, look at this, it's in the U.S. Code. And now Section 93 cases are the most common civil rights cases brought throughout the country, in the thousands. So there are laws on the books that sometimes people don't even realize are there. So do your thorough legal research, and if the law isn't on the books, then, you know, call Julie and make sure that she gets that law on the books in your jurisdiction.
I think that is a perfect end on. I want to thank you all so much, Blanca, Julie, Ilan, and Zoe, for presenting today. I think this was a really informative, interesting, and dynamic discussion. We are thrilled to be able to share your expertise with folks in the Legal Network for Gender Equity. We are going to be posting a recording of this webinar on our website, and our presenters have agreed to make their slides and some materials available on the website. So look for that after today, and let your colleagues know that if they weren't able to join the webinar today, they can listen to the recording later on. Thank you again to our presenters and to my colleagues here at the Times Up Legal Defense Fund at the National Women's Law Center, who have helped to bring this webinar to all of you. And that will conclude our webinar. Look out for more to come in future months. Thank you all.
Thank you.
Thank you.